Hello friends, welcome to the channel. Friends, no guidance on GDPR is complete without a clear understanding of the Schrems cases. Let's learn a bit about Schrems I and Schrems II case. But before that, a little bit about Maximilian Schrems. Schrems is an Austrian lawyer and one of a prominent activist in the fight for privacy. He founded an Austrian-based privacy NGO called None of Your Business. Schrems has filed GDPR complaints against giants like Amazon, Apple Music, Netflix, Spotify, Facebook, YouTube, etc., to name a few, on the grounds of GDPR violations. So, friends, let's have a look at Schrems I case. This case was filed by Schrems in 2013 after Edward Snowden revelations came out. These revelations exposed large-scale surveillance programs by United States intelligence services wherein they collected internet communications from various US internet-based companies to collect intelligence on non-US citizens. This meant that US government had access to large amounts of data from Google, Facebook, Apple, etc. And hence, Max Schrems challenged the validity of the Safe Harbor network because it could not adequately protect the fundamental right, that is, the right to privacy of EU users. Now friends, a little bit about Safe Harbor Framework. This framework was established in 2000 and was an arrangement between the European Union and the USA wherein those companies that would self-certify their compliance with the European data protection standards were allowed to transfer data from EU to the USA. Now, since Facebook's European headquarters are in Ireland, Max Schrems brought this case against Facebook with the Irish Data Protection Commissioner and asked them to prohibit any further transfer of data from Ireland to USA until they could assure adequate protection of the personal data of EU citizens as was required under the European law, and also to ensure respect for EU citizens' fundamental rights. So friends, this case finally reached the European Court of Justice, and on 6th October 2015, the European Court invalidated the Safe Harbor framework on two primary grounds. Number one, it did not sufficiently protect the privacy rights of EU citizens. And number two, they also stated that considering the US mass surveillance programs, no effective legal remedies were available to EU citizens whose rights were violated, and this was in complete violation of their fundamental rights under EU law. So friends, as a result, to replace the Safe Harbor framework, the Privacy Shield Agreement was introduced in 2016. The main difference between the two is that, on the one hand, Safe Harbor framework was established by the European Commission in 2000 as a self-certification program. Privacy Shield was a negotiated agreement between the European Union and the United States government, which was intended to provide stronger privacy protections by incorporating requirements for data retention, purpose limitation, accountability, transparency, etc. Another mechanism that was also available and is still valid for data transfer are the SCCs, that is, Standard Contractual Clauses. Now, SCCs are a set of standard contractual clauses which are issued by the European Commission. These clauses are used to ensure that adequate safeguards are in place whenever personal data is transferred from the European Union to a third country that does not have an adequacy decision from the European Commission. Now friends, adequacy decision refers to European Commission's assessment of whether a non-European Union country, this is a country which is not a part of EU, provides an adequate level of data protection or not. So friends, SCCs are a widely used mechanism for data transfer, and they provide a legal framework for protecting personal data during the transfer process. Now, Facebook used SCCs to transfer data to the USA and would ask the users, naturally, to sign the contract. But it did not allow the users to use this clause in those cases where there was a conflict with the law of the country where the data was being transferred. And that country in this case was US. So friends, Schrems contended before the Irish DPC that the US surveillance law, that is FISA 702, is still valid in US, and hence the judgment in Schrems I case should apply to these instruments as well, like Privacy Shield. And here, the Irish DPC halted proceedings and filed a case against Facebook and Schrems before the court, and that's how Schrems became a defendant in this case. So basically, Schrems II case was a continuation of the Schrems I case, except that here the Irish DPC did not decide on the point. Instead, it challenged the validity of standard contractual clauses before the court. Here, Schrems contended that SCCs are valid because they do not allow for transfer of data under certain situations to the US. However, Schrems still challenged the validity of the Privacy Shield framework before the Court of Justice of the European Union. In short, we can say the European Court of Justice. Max Schrems argued that Privacy Shield did not provide adequate protection for the privacy rights of European Union citizens when their personal data was transferred to the United States. The European Court of Justice decided this case in 2020. The court declared Privacy Shield as an invalid agreement because it did not provide adequate protection for the right to privacy of EU citizens in the light of US surveillance programs. Now friends, as regards the surveillance programs, the court observed that surveillance conducted under Section 702 of US Foreign Intelligence Surveillance Act, known as FISA in short, involved bulk collection of personal data. The court also expressed concerns about the absence of clear limitations on the scope and application of US surveillance activities, which meant they could collect personal data on a generalized basis without any justification. Court also observed that EU citizens whose data was transferred to the United States might not have sufficient remedies to challenge any violation of their rights as a result of the US surveillance practice. And that is why the Privacy Shield was struck down. But the second point of significant consideration were the SCCs, that is the standard contractual clauses. The court upheld the validity of SCCs for data transfers, but the court stressed that data exporters are under an obligation to ensure that the data subjects get an equivalent level of data protection as is available to data subjects in the European Union. Some of the things that they said were: number one, companies transferring data must assess whether the country to which they are transferring the data provides adequate level of protection that is equivalent to the one guaranteed within the European Union. Number two, if the destination country does not offer such protection, which is equivalent to the EU, or there is no such protection, then the companies must implement supplementary measures to ensure equivalent safeguards as is available in EU. These measures could include encryption, pseudonymization, access controls, etc. And the court also said that SCCs are contractual clauses that are approved by the European Commission, and these help in ensuring safe transfer of personal data outside the EU. The court held, however, that companies can use SCCs as a means to transfer data, but they must ensure that these clauses are implemented effectively, thereby providing adequate protection to the data subject's right. It was also decided here as to what is the meaning of European law, especially when we say, and I quote, data transfer to third countries should be provided protection equivalent to that under the EU law. So EU law, the court said, is basically GDPR, which is read or which has to be read along with the European Charter of Fundamental Rights. The factors to be taken into account are appropriate safeguards, enforceable rights, and of course availability of legal remedies to the data subjects. Friends, the core idea under GDPR is expressed under Article 49 of GDPR, that personal data cannot be transferred to third world except under very limited circumstances. The reason behind this rule is that if there are restrictions on processing of personal data in Europe, then the same restrictions should apply on data processing when that data is transferred to another country. And no such processing should be allowed on that data which is not allowed under GDPR or cannot be performed in the EU. Otherwise, any company could transfer data outside of Europe and do whatever they want with it. That's why GDPR has an extraterritorial jurisdiction, as it expects the companies to respect the right to privacy of data subjects, whether their data is in European Union or another country. The data subject's data should get the same protection wherever it is transferred. That's why, friends, more and more companies are now planning on opening their data centers in Europe so that they can be GDPR compliant. The US government is also negotiating a new deal with the European Union as regards a new framework for data transfers which will be aligned with GDPR. However, the agreement is yet to be finalized. The main sticky point are the US surveillance laws, which are a cause of concern with the European Union because the US surveillance authorities have too much access to personal data that is transferred from European Union to the US. It is presumed that US has agreed to make some changes in its laws, but nothing concrete has come out of it. Friends, so let's wait and see what will be the outcome. Till then, as things stand currently, SCCs are the most common and promising way to transfer data from European Union to the third world, including the United States. But most important thing to keep in mind is that the data transfer must provide adequate protection to the right of privacy of European data subjects whose data is being transferred. So friends, I hope you like this video. This video gave you a nice understanding and a summary of the two Schrems cases and why they are important in the current context. Thank you so much for your time, and I'll see you soon with another video. Till then, goodbye, take care, and have a great day.